Okay, this is the 100-120 class. This will be some congressional material for practice, for the record. Mr. Speaker, I appreciate the comments of the gentleman from California. I think the gentleman has made some very important points. I am advised now that this fiscal 2005 budget is the 10th consecutive year of real cuts in defense spending, and that we are approximately 35, as much as 40% below the level of spending in real dollars than we were in the 1996 budgets in the last several years of President Reagan's term in office. What is very interesting is I am advised under the Bush administration that cuts proposed resulted in cuts of personnel of approximately 600,000, meaning not only cuts in the military, but lost jobs in the defense sector. And that when we consider the current cuts proposed in the current administration's budget, that could be 1.2 million jobs in this country. You know, jobs are important not only because of the fact that they give productive employment to our citizens, but they also represent some of the highest paying jobs in this country. But even going beyond that, this is about much more than jobs. It is about making sure that we have a strong national defense and that we are applying the resources that we need to meet the crises that we may be asked to confront. Again, I am appreciative of the administration's effort to reinvent government, but it might interest our listeners to know that although the Department of Defense only comprises 40% of the civilian workforce in this government, as much as 75% of the cuts in full-time equivalent positions are occurring in the Defense Department in the area of defense. I do not think that it is fair that the Defense Department is unjustifiably singled out, particularly given the level of commitments that we currently maintain. There is also a more important point that needs to be made. Our defense budget must be in line with our commitments. There is a need for a balance. Our commitments cannot exceed our resources, and our resources must be adequate to our commitments, but they have to be in balance. Neither one can be out of line with the other, because if we do not have the resources we need to cut back on the commitments, we have a big problem. And by the same token, if we make the commitments, we have to make sure we have committed adequate resources to be able to fund our objectives. I am advised that based on the administration's own bottom-up review, 2 separate analyses of the bottom-up review indicate that the strategy that the administration is pursuing, including as it relates to the funding, is that there are discrepancies everywhere. In the case of the General Accounting Office, there was an estimate that the defense was being underfunded to the tune of $150 billion. By the same token, the Congressional Budget Office made a similar estimate of between $65 billion and $110 billion underfunding. That means that based on the structural needs identified in the bottom-up review, based on our national defense strategy and the defense strategy and the threats that we could potentially face throughout the world, including the need to face two regional crises simultaneously, we are not committing the resources that we need to meet the threats. In fact, there is some question not only whether or not we can confront two regional crises, but whether in fact we would be able to sustain a single major crisis. Obviously, we have got a level of commitment and dedication in our armed forces. I have every confidence that they are highly motivated and that they are doing the best to maintain their training and readiness. And I know that they are dedicated enough and will meet any mission that we might assign to them. But again, the underfunding, based on the level of commitments that we seem to be seeing throughout the world, indicate to me that it is time for very serious re-examination. I might mention, as I mentioned earlier, we passed the Congressional Accountability Act, which is applying to the Congress the same standards that we apply to the private sector. We passed the balanced budget amendment in this House and sent it off to the Senate. Again, we passed a clean amendment. We have protected no area of the government from scrutiny that the balanced budget amendment will force. I might mention that 2 days ago, the House Committee on National Security, formerly the Committee on Armed Services, as I mentioned, worked up and marked up for forwarding to the House floor, H.R. 7, the National Security Revitalization Act. And again, it is important to know that we are following consistency and principle in the way we address these issues. H.R. 7 is an important first step toward restoring United States national security to the levels expected by the American people. It establishes a policy framework on national security issues, a policy framework that is designed to establish the threats that we face and provide a framework by which the party, the new Republican majority, and the Democrats in the Congress, through the normal budget authorization process, can ensure that we are dealing adequately with needs of our defense and the resources that it might compel. But what is very significant is that this bill passed on a bipartisan vote of 41 to 13. Again, a very strong commitment from members of both political parties behind a National Security Revitalization Act. All right, this will be some legal material for the record. Ladies and gentlemen of the jury, first I think we should discuss the procedural aspects of the case. I do not believe that there is a bona fide standing on the part of Mr. Fahey and Mr. Willis to attack the confessions of Mr. Trapp and Mr. Morey. I will submit that is true because I know the court is well aware of the standing espoused in People versus Victor and other similar cases that have been mentioned. Detective Fahey was quite candid with the court. The only persons that knew anything about the tape recorder or made any recommendation about it were the defendants Maury and Trapp. They indicated a desire that it not be used during the interrogation. Mr. Willis, as far as I know, based upon the evidence thus far presented, knew nothing about the tape recorder. As Mr. Fahey testified, it was necessary to crane your neck and turn almost completely around in order to see the tape recorder. I submit at this time to the court that I don't know where counsel gets the picture of 5 or 6 people hovering around Mr. Willis. There were no such implications. I can't see that from the evidence. As I recall the testimony, and I know the court has taken exhaustive notes on this, Mr. Willis was interviewed by Detective Fahey and Mr. Gilgan. The last ground raised by counsel, that is, of attempting to get or say that the court should espouse a new rule requiring tape recorders, that is not the law at this time. He hypothesizes that that is the best way to do it. I submit that it is not the best way. One of the major problems here is that you are talking to a man. You are discussing attempted murder. You are discussing what he has done. You are talking to him about things such as the following. Have you been arrested before? Have you ever done hard time before? When you were in the joint, what was the last thing that happened to you? All of these questions and more are on the tape. So as the court is well aware, and as we all know, it isn't illegal to discuss all these things in getting statements from a particular defendant, but those things are not admissible in court. Now let's go on to the real crux of this case here. The real crux of this case is obviously whether those 2 men in the back row were beaten. The question is, were they beaten? Both counsel have been practicing attorneys in this town for years. I know both of them. One is the past Deputy District Attorney of Boston. I know he has been in the office several times. I have seen him. He has worked for the Darien Department of Legal Services as well. He was also over in the Cambridge office for a while. Now, getting back to the facts here, I respectfully call the court's attention to People's Exhibits 5 and 6. These are the medical reports. 2 individual and independent examiners examined both Mr. Maury and Mr. Trapp. There were no bruises. There were no cuts. There were no broken bones. There were no abrasions and lacerations. There was no internal bleeding or other noticeable injuries to either Mr. Maury or Mr. Trapp. Let's look at the conception of forced confessions within the United States. The law goes back to 2 cases. One of them involves a man named Clark, and right now the other one seems to have slipped my mind. These are 2 cases arising in the South way back in the early 50s, I believe. They are some of the first 2 cases taken to the Supreme Court of the United States. Perhaps if we were in the 50s, I would say that what counsel says makes sense, but I will submit this to you that we have no indication whatsoever of any beating taking place. This was not presented in any way, shape, or form in the testimony of these 2 defendants. Your Honor, I would submit that the sophistication of law enforcement has certainly gotten to a point today where no police officer who is going to inflict a corporal type of punishment upon a human being in order to get him to confess is going to be stupid enough to hit him in the face. That is what they want you to believe. The hitting isn't going to be in the ribs either. They are subtler ways that can be used. The police officers don't hit anymore because the current cases talk about psychological coercion, of which there is just insufficient evidence here to believe that. The testimony we are supposed to believe from Mr. Morey is that he hardly sat down in the chair before the officers started hitting him. Now he has his wrists handcuffed behind his back, and he is being hit. There isn't one iota of testimony to show that anywhere there are any injuries on the wrists or anywhere else. I submit that we don't have the burden in this case any longer, even if we had one to begin with. There was no beating. If the court feels that I have missed any particular point that I should address myself to, I have every confidence that you will tell me so. Thank you for your patience, Your Honor.